I've got some terminology here that I'll run through before we get going, just so you understand what I mean when I use certain terms. Because often when speaking to our clients, these terms are used incorrectly. Resignation is when an employee terminates an employment relationship, and typically resignations do not give rise to any compensation other than the wages that the employee had already accrued and had yet to be paid by the date of the resignation. Termination is commonly when the employer terminates the employment relationship, and it could result in a situation where the employer owes the employee obligations or not, and I'll get to that in a second. Layoffs are different than a termination. Under the Employment Standards Act, when there's a shortage of work, or really I think for any other reason, you can lay off an employee for not more than 13 weeks in a 20 consecutive week period. The problem with that is you would need an entitlement in your employment contract to lay off an employee in order to exercise the Employment Standards Act entitlement, because a layoff would generally be a constructive dismissal, which I'll get to in a second. And then you have your termination with cause and termination without cause. Termination with cause is referred to as the capital punishment of employment law. It's a very high standard. The employee has to do something to completely undermine or make the employment relationship unworkable. Theft, fraud, extreme cases of disobedience, prolonged culpable absenteeism. That means absences that are not caused by a disability. These are all, performance is a very difficult one. You need to fire someone with cause for poor performance. You need to have clear, reasonable expectations. Those expectations must be clearly communicated to the employee. The employee must know that his or her job is on the line if they fail to meet those expectations. And you have to give the employee a reasonable amount of time to rectify the performance problems. And then termination without cause is really what happens most of the time, and the employer owes the employee accrued wages, vacation pay, his or her entitlements under the Employment Standards Act, and most often, if you don't contract out of it, pay in lieu of notice. So generally, you have to give the employee notice that their job is ending, or pay in lieu of that notice. And I'll get into these details right now. So if you were dismissing an employee on a without cause basis, the first thing you have to do is meet your minimum requirements under the Employment Standards Act, and there they are on the slide. Unpaid wages and accrued unpaid vacation pay have to be paid. Then you have to pay the employee termination pay. After 3 months of service, the employee is entitled to termination pay, and that's a 1 week per year of service up to 8 weeks, plus a benefits continuance for the same period of time, plus the vacation pay that accrues during that same period. If your payroll is $2.5 million or greater and the employee has served you for more than at least 5 years, then additionally you have to pay the employee severance pay, which is a week per year of service up to 26 weeks. So those are your minimum standards, and as Richard has mentioned before, there are your common law obligations to an employee, which are generally more expensive or more onerous for employers. And implied in every contract is a term that means it's not written, but the court will imply it, that the employer has to give the employee sufficient notice or pay in lieu of notice when firing the employee on a without cause basis. And the amount of notice is determined by, it's not a mathematical formula. There are a number of factors that are considered. The 4 main factors are the employee's length of service, age, character of employment, and availability of similar employment. So the longer you serve, the more notice or pay in lieu of notice an employee is entitled to. The older an employee gets, the more difficult it is to find work. So that would drive up the notice period or the pay in lieu of notice. The character of employment, if you were a CEO, those jobs are a lot more difficult to find than if you were an entry-level salesperson. So the higher level job will demand more pay or more notice or more pay in lieu of notice. And the availability of similar employment is an obvious one. If it's a recession, it's very difficult to find similar employment at the time. That will drive up the notice required. All of that is subject to the duty to mitigate. So if you have, let's just take an example here, you have an older senior employee, 60 years old, we'll say 17 years service at a management position, likely that the court is going to find that you owe that employee somewhere near the top. The cap is 2 years pay or notice. So you'd likely, let's just assume the court finds that you owed the employee 22 months notice or pay in lieu of notice. And if it was a situation where you summarily dismissed the employee, meaning you told the employee, look, I'm firing you on a without cause basis, but I want you to leave today, then the obligation would be for you to pay that employee 22 months. All of the compensation that employee would have normally earned over a 22-month period. Or you could sit down with the employee and say, I'm firing you on a without cause basis, and your employment will end in 22 months, and the employee will work through it. If you fire the employee, summarily dismiss them, meaning you tell him you fired and you ask him to leave immediately, then the employee has a duty to mitigate, meaning the employee just cannot sit at home and wait for you to pay him or her 22 months pay. He or she has an obligation to make reasonable efforts to find similar work, and if that work is offered, to accept it. So if the employee ends up working in 12 months, then really the damages would be capped at 12 months. Constructive dismissal. This occurs when you don't fire the employee, but you do something to constructively fire the employee. A demotion, change in responsibilities or hours. It's the legal, the Supreme Court of Canada defined a constructive dismissal as a unilateral change to a fundamental term of the employment contract. So if the employee was hired on days and you switch the employee to night shifts, for example, or you reduce the employee's compensation, or in some cases, a geographic transfer, all of these can constructively amount to a constructive dismissal, and it essentially, the court will find that the employer, by its actions, showed an intent not to no longer be bound by the employment contract, and the employer would be allowed to walk away from the agreement and then claim damages as if he or she had been dismissed. The disabled or ill employee, my first recommendation is that you call us if you're dealing with an employee, or thinking about dismissing an employee who is disabled or ill or showing signs of a disability. Most employers want to know, well, how long do I have to keep an employee's job open? And this is referred to as the doctrine of frustration. And it's a situation where, due to a disability, a prolonged disability, the employee can't show up for work, and the employment contract will end as a result because it just doesn't work anymore. The employee is unable to work. The doctrine of frustration doesn't kick in until a 2-year absence, continuous absence, and following that 2 years, there is no prognosis for recovery in the near future. You have to have at least that. There's a recent decision in the Supreme Court of Canada where that was approximately the case, and that wasn't good enough. So you need something north of 2 years. We don't know what it is. The laws have really been set on that. And there are serious consequences for a premature termination in these situations, where even in retrospect the employee remains disabled, and the court will know, well, had things continued in their normal course, the employee would have never been able to return to work. compensation will still be owed because the court will make their assessment based on the information the employer had or could have had on the date they declared that the contract was frustrated. One of the largest sources of liability is for when dealing with any employee, but certainly disabled employees, liability for long-term disability benefits. Many employers offer long-term disability benefits coverage. It's an income replacement benefit that kicks in when an employee meets the definition of disability under the policy. It pays the employee approximately, usually about 66% of his or her income during the period until he or she is able to work or until he or she turns 65. So if you dismiss an employee who's disabled and during the notice period that employee becomes disabled and is unable to claim long-term disability benefits as a result, then the employer will be liable for compensating the employee for those lost benefits, which could, in extreme cases, mean the employer would pay those disability benefits until the employee reaches the age of 65. The Human Rights Code, we haven't spoken much about at all about that today, but there are certain protected grounds that cannot be a factor in any decision before, during, or after the employment relationship. These are things like sexual orientation, sex, disability, ethnic origin, marital status, family status. There are a few others. So if you're an employer and you're dismissing an employee, you have to make sure that one of those protected grounds is not a factor in the decision. And if there is some basis to believe it was, then you and the employee files an application with the Human Rights Tribunal of Ontario, you as an employer will have the burden of proving that the factor had nothing to do with the decision. And the consequences can be significant. It could include an order for reinstatement, lost wages, including future lost wages. So if you fire someone who's about 62 years old, and you would have normally worked to the age of 65, you're looking at 3 years' wages. And then general damages as well, which could go as high as 20, maybe slightly higher than $20,000 in severe cases. Finally, there's the duty of good faith and fair dealing. Employers are expected to be candid, reasonable, honest, and forthright with their employees when conducting a dismissal. And employers will be liable to an employee if they breach that duty and the employee suffers mental distress as a result of unduly, insensitive, untruthful, misleading treatment. Usually this is the common sense situation where if you're going to fire someone, you're going to do it in a very professional manner. I like to have my clients have at least 2 representatives at the meeting. They should have a good idea what they're going to say before the meeting, perhaps do speaking points. They should take notes after the meeting. They should think of the employee, the departing employee, in terms of ensuring that he or she will be able to leave the workplace with dignity, which includes you want to resist a situation where you're escorting an employee out of the workplace and certainly by his or her former colleagues. The only problem with this is that sometimes relationships just become so bitter and tense that by the time you conduct the termination, some employers, it's almost like a form of retribution, and they just kind of lose perspective, which is a good reason to retain counsel well before you make any decision to fire an employee, and then in the course of conducting a dismissal and a sort of with retribution, they end up violating this duty and paying damages as a result. So examples of conduct that will amount to a breach of this duty: attacking the employee's reputation by making declarations to others at the time of the dismissal, misrepresentations regarding the reason for the dismissal, making wrongful accusations when you know or ought to know you're not going to be able to prove those accusations, firing an employee when the employee is on a disability leave,